Very good afternoon to all the listeners. I am Ms. Chinki Verma, Assistant Professor, IIMT College of Law, Greater Noida. Today, the topic I'll be discussing is Women's Right to Abortion and Medical Termination of Pregnancy Act 1971. So, before starting with the discussion of the act, first we need to understand the main provisions of law. That is, before discussing any specific law, we need to start with the main major legislation of criminal law, which is IPC. So the Indian Penal Code IPC under section 312 and 3116 provides a blanket ban on the practice of abortion. Now, what does this blanket ban mean? This means that under no situation a woman is allowed to abort her child. This abortion will extract penal penalties for both the mother and the abortionist. Now, what does we mean by this term abortionist? Abortionist here could be a doctor, a midwife, or any other person who is helping the woman to achieve abortion or miscarriage. Now, under these section, only one exception is recognized. That is when the abortion is caused to save the life of the mother. Apart from this, any other situation, if a woman undergoes abortion, she will be punished with penal penalties, and which could also extend to imprisonment of considerable amount of time. So these now this strict ban on abortion was resulting in women to like go for unsafe methods of abortion, and women were opting for backstreet abortions. Now these backstreet abortions are not medically safe. These women were inflicting harm on themselves, and the women mortality rate, fertility rate was considerably decreasing in India. Now the government of India recognizing that such a practice could be harmful for the whole nation and could brought down the Indian mortality rate. So what Indian government did was that they established a committee known as the Shah Committee. Now, why Shah Committee? Shah Committee because the chairperson of this committee was Dr. Shah, who was a medical expert, not a legal expert. Though the committee was set up to suggest legal changes, but the expert of this committee was not a legal expert but a medical expert. This shows the government's paternalistic stand. That is, the government wanted the changes in the law to make not to make it more in line with the legal philosophy, but to make it more in line with the principles of respect for life and liberty. What we wanted was not to change the laws to make to make the concept of justice more accessible. What we actually wanted was to make laws such so that the loss of life and liberty could be decreased and women could be given a right to choose for herself. So this committee was established, and this committee did a comparative analysis of the laws of various nations and their situation in India, and make analysis as to what could be done to improve the situation. Now, as a result of this committee suggestion, the MTP Act 1971 was enacted. Now, during the last 30 years, many countries such as Great Britain, Greece, Spain have made their abortion laws flexible. India, as a result of which, also has undertaken various amendments to make the laws flexible. There are many nowadays there are many countries which still have strict and rigid abortion laws. For example, like even after the enactment of MTP Act, the IPC section, that is section 312, is still applicable. It's just that its effect has been reduced a bit. The section of IPC is not made inapplicable. What has been done is that under certain situation under MTP Act, abortion is allowed. If a woman is able to claim those situations, she'll be allowed to abort. If not, she'll be punished for the penal offense and could even be given imprisonment sentence. Now in India we have not, as per legalized abortion, we have just relaxed the laws. But in USA, after the 1973 Roe and Wade judgment, what they have done is that they have made the law of abortion very flexible. They have said in the US Supreme Court said in this judgment that US citizens have a right to abortion, which which is a fundamental right. Every woman can abort a child if that child is undesirable or the woman is not ready for the child yet. But in practice, what actually happens is very different. Though, as we know, US is a federal state, it has a federal government and various other states. So these states have a right to make laws for themselves. So using this power, these various states have made different abortion laws, and as a result, what happened is that most of the US states does not allow abortion under any circumstances. They like Texas, they only allow abortion in cases where where such continuance of pregnancy will be harmful for the life of the mother. Apart from that, no other exception is recognized. But in India, where in comparison to US, uh, the law of abortion is not very liberalized, but still the women in practice have a much more flexible right of abortion than the US citizens. Now the MTP Act, that is the reason why MTP Act was considered ahead of its time. Now the Medical Termination of Pregnancy Act, according to the 1966 report of Shah Committee, such act was required to save women from loss of their lives. This MTP Act removed a blanket ban on the practice of abortion and under Section 3 produced certain clauses where a woman could be allowed to abort the child. Now, what are these clauses? First was if now this act has divided these clauses under two time periods. First is 0 weeks to 12 weeks, and other is 12 weeks to 20 weeks. Now, what does this 0 to 12 weeks mean? This 0 to 12 weeks uh, means the age of the fetus. If the fetus is 0 to 12 weeks old, then women with the permission of one medical practitioner can abort the child, provided first the continuance of pregnancy will be harmful to the life of the woman. Second, if the child if the child is uh, if the child is causing any mental or physical harm to the woman. Now, what does mental harm mean? Under the explanation of this act, this explanation one specifically provides that if the child is conceived as a result of any failure of conception device, then it will be considered that the child is causing mental harm to the woman. Now, this means if the child is not planned, it is a result of failure of any conception device between the married couple, that is a woman, a wife, and a husband. Then there will be a presumption of mental plurality, and the spouses, the woman and the husband, the wife and the husband will be allowed to abort the child. One thing that has to be noted here is in this 1971 Act, the Act was using the language between a wife and the husband. So there was a presumption of marriage. For a woman to abort the child, she needs to be married, and so unmarried woman was not allowed to abort. This has been changed after the 2020 amendment, which has removed these phase and added the phase that any failure of conception device between a woman and her partner. So there's no requirement of marriage. Even an unmarried woman is not allowed to abort. Now, what are the other changes? Other changes are first, now if we in India also have now started recognizing the rape exception. That is, if the child is conceived as a result of rape or any sexual violence to the woman now will be allowed to abort the child, because under such circumstances, forcing a woman to bear the liability of a sexual offense will be like increasing the harm which is already inflicted on her. So now, after the 1971 Act, we have allowed the woman to abort the child if that child is a result of rape or any sexual violence. Apart from this, other exception which recognized is the exception of any bodily harm. No, any bodily harm. That is, if the child is born, if there's a medical proof that if child born he or she will be born with a considerable medical defect, so that make his or her life after delivery very difficult, then the woman will be allowed to abort the child. Apart from that, there's one other exception, that is if the continuance of pregnancy is again is against the life interest of the woman. That is, if the pregnancy is continued, that will be harmful to the life of the woman. Now under that cases also she'll be allowed to abort the child. Now what has to be seen here is that after the 2020 amendment, this time period, which was earlier 12 weeks, has been extended to 20 weeks, and the other time period, which is the time period which was other time period which was 12 to 20 weeks, has now been replaced to 20 to 24 weeks. Now, in 20 to 24 weeks period, if the fetus is 20 to 24 weeks uh, uh, long, then in such cases the woman will be allowed to abort the child if the uh, if if two medical practitioners allow such abortion. Now, in any abortion laws could be looked from two standpoints, that is of the mother and that is of the fetus. Now, in any abortion discussion, two ideologies work. First ideology is that for the right to choice, that is, women should be allowed to choose for herself whether or not she want to continue the pregnancy or not. And other psychology that work or is that with from the standpoint of fetus, which is the pro-life philosophy, which says that the child, if conceived, has the right to be born alive. He or she has the right to continue the life, has the right to live, and no other person, whether even the mother of that child, could be allowed to end his or her life. That child has a fundamental right to life, and no one can take this right from him or her. So, abortion law of any state is a continuous conflict between these two ideologies, that is, the pro-life ideology and the pro-choice ideology. India before 1971 was more inclined towards the pro-life ideology. That is, we were advocating that the woman should not be allowed to abort the child because that child has a right to life. But after suffering the negative consequences of such a philosophy, and discovering how strict and stringent law strict and stringent law could result in loss of life of the woman, and women fertility and mortality rate could be increased. So we realize, yes, we need to change our ideology and shift towards a pro-right ideology. So in the current scenario, in the contemporary times, there's a movement from the pro-life ideology to pro-choice ideology. Now what we believe is that the woman has a right over her own body. She has a right to choose for herself whether or not she wants to continue the pregnancy. If she chooses that she doesn't want to continue the pregnancy, she should be allowed to uh, abort the child, and and she should not be forced to go through the whole conceiving period or gestation period. Now, what does this uh, consistent objection clause mean? Now, our Indian MTP Act is wholly inspired or taken from the Britain Abortion Act of 1967. Most of the section of MTP Act is similar to that of 1967 Abortion Act of Britain. The only difference between both the acts is that of a consistent objection clause. That is, now what is consistent objection clause? Consistent objection clause is that if any abortionist or any medical practitioner is of the opinion that being involved in the practice of abortion, providing any support in the abortion of any woman, will be against the religious against the religious ideologies of that medical practitioner, then that medical practitioner cannot be forced to take part in the practice of abortion. However, in India, we doesn't have such a consistent abortion clause. However, we do have religious right. So, if such no, as of now, no such question has been raised before the Supreme Court of India that if 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 the case is such that the medical practitioner is not willing to undertake take part in the practice of abortion, and the support of that medical practitioner is such that we in that particular case require his help. So can we force that medical practitioner to provide his medical expertise and support? So as of now, no such case has been raised before the Supreme Court. So it's a debatable point whether or not that medical practitioner could be forced to undertake the such undertake undertake or to provide his medical support in the practice of abortion. Now, how does the Indian judiciary interpret the MTP Act? In Suchitra Srivastav and other versus Chandigarh administration, which is a case of 2009. In this case, uh, a woman wanted to abort a 20-week period fetus. In this case, the court disallowed the woman to abort her child and held that the particular period decided in the MTP Act is due to the medical opinion that the abortion performed during the later stages of pregnancy can cause harm to to the physical health of the woman who undergoes abortion. So here this inclement towards the paternalistic approach. The court or rather the government as the parent or as the guardian of the woman want to protect her life, which is the reason why we have provided a 20-week period. After this 20-week period, we are not allowing abortion because undergoing such abortion could be harmful to the health of the woman. And then A versus Union of India case. In this case, also court allowed abortion of 24-week period fetus because the court held that such abortion will not be harmful to the life of the woman. That's the reason such abortion was allowed. In Indu Devi versus State of Bihar, court disallowed abortion or 20-week fetus. Though the 20-week fetus abortion is allowed in the MTP Act, court disallowed such abortion because undergoing such abortion was against the life interest of the woman. She could have there was a risk of life of the woman, so the court held that no, such abortion could not be allowed. So it could be said that the Indian Supreme Court, Indian judiciary also interpret the MTP Act under in paternalistic language. Now, MTP Act under IPC doesn't use sorry, the Indian Penal Code under Section 312 doesn't use the word abortion, whether the word causing miscarriage is used. According to Article, the main reason why we are using the word miscarriage, not abortion, was because the Indian Indian uh, society has an inclement towards moralization where taking life of another was considered a moral crime. Thus, we were not using the word abortion. Rather, we were using the word miscarriage. Now, under Section 3 Explanation 1, 1 of the MTP Act, we make rape-induced pregnancy a special case. That is, as discussed earlier, a woman who has been who was impregnated as a result of any sexual violence is now allowed to abort the child. About the child, she cannot be stopped taking the plea that IPC condemns such abortion because under MTP Act a special clause is provided where rape-induced pregnancy is considered a special case. A woman will be allowed to abort the child. But here, one thing has to be noted that our main concern is to save the life of the woman, even if the case is of rape-induced pregnancy. If undergoing abortion will be against life interest of the woman, if undergoing such pregnancy will result in loss of life of the woman, she will not be allowed to abort the child. Now, one wonderful suggestion uh, introduced by the MTP Bill 2020 was that the bill suggested that we should make incest a special case. Well, now, what does incest mean? Incest is not a term defined under any law, but in general terms, incest means relation that is forbidden by the moral law. For example, a father and a daughter, a sister and a brother, such relations. Now, such relations will be considered incest, and a woman is if woman is impregnated as a result of incest. For example, if a woman is impregnated by her father or brother, now in such cases, a woman will be allowed to abort the child. This is what the 2020 bill suggested. They wanted to introduce incest induced pregnancy as a special case, just like the rape induced pregnancy, but such suggestion was not ultimately taken, and in the MTP bill of 2021, incest was not included as a special case. Now, what are the recommendations that I would like to suggest? First, uh, for any registered medical practitioner to be qualified to perform MTP, it should be noted that a medical practitioner must have assisted at least 25 MTP cases in any authorized center, or must have a certificate for such practice. First, second is uh, he or she must have got 6 month house surgeon training uh, in gynecology or obstetrician, and one must have got diploma or degree in such practices. No. Now, what other thing that I would like to discuss is that MTP Bill 2020 is a new way of light for women who wants to practice safe abortion, and for those who wants to legally terminate the pregnancy. However, India has a long way to go and eradicate the practice of unsafe abortion. What we require in India is a fundamental change in ideologies. Though the Indian abortion law is considerably flexible, and though we do not have a fundamental right to abortion, but in practice a woman is allowed to undertake the practice of abortion under various cases. But what we require now is a legal precedent, a legal enactment to give a woman such right. Now, other thing we could about abortion we could discuss is that uh, related to consent. Now, if a woman wants to undergo abortion, does she requires the consent of her spouse? The answer is no. In India, Indian judiciary in various cases has held that a woman has full right over her body. A woman is not a baby producing factory. She could not be forced to undergo pregnancy if she is not willing to. If a woman wants to undergo abortion, the only consent we require is that of the woman herself. His spouse plays no role in it. If the woman wants to undergo abortion, even if the spouse of the woman, that is her husband, is against abortion, that woman cannot be disallowed abortion. She'll be allowed. What will be the scenario if the woman here is a minor? In such a cases, as in India, we do not consider a minor fully able to give his or her consent. So, a woman, if she is minor, she would not be allowed to undergo abortion on her own will. Rather, her parents will be the one who will be choosing it. So, if the woman is major, she'll be allowed to abort on her own will. But if she is a minor, she won't be allowed to abort on her own will. Rather, the consent of the parents will be taken. Other thing that has to be discussed is that related to the counseling practices in India. We do not provide pre-abortion or post-abortion counseling, but in USA there is a provision for providing compulsory pre-abortion and post-abortion counseling to the woman, because so that she could make a informed decision. She could know what will be the mental and physical effects on her body if she chooses to undergo the abortion, or if she chooses to continue the pregnancy. But in India, we do not have such provision of compulsory counseling, I think that is something we should include in our laws. Women should not only get pre-abortion counseling so she could note the consequences of it, but she should also get post-abortion counseling so could uh, she could resolve any other query or any other problem that she might face in the future because of such abortion. Uh, I think that is pretty much all. Thank you.